for the First Amendment, somebody, one of those 90, surely would have said something about it. But no one did. Not a single word said about it. What then is the origin of the phrase separation of church and state that today so many consider? It's a phrase that appeared in a private letter penned by Thomas Jefferson 13 years after the First Amendment had been written. Throughout his life, Thomas Jefferson had proven himself to be a firm friend of religious liberty. In fact, before the Revolution, in his own state of Virginia, he had fought for freedom of public religious expression for Baptists, Quakers, Presbyterians, and others who were not part of the British state-established Anglican Church. In various colonies prior to the Revolution, non-Anglican ministers had actually been severely persecuted and even been put to death for preaching the gospel without permission of the state-established church. Therefore, founding fathers such as Jefferson, as well as Patrick Henry and James Madison and George Washington and George Mason and others, they fought for the rights of religious expression for all Christians, including the Baptists. They fought for this right before America separated from Great Britain, and they continued to do so afterwards. Years later, in 1801, Jefferson became the nation's third president. And not surprisingly, the Baptists were elated. After all, a man who had proven himself their champion at the state level was now the national leader. Jefferson received letters of congratulations from Baptist groups across the country, including one from the Baptists of Danbury, Connecticut, congratulating him on his victory, celebrating his election as president, and offering their prayers for him. However, they also expressed their concern that the government might restrict their public religious expressions. They believed that freedom of religion was a God-given inalienable right and that the government should be powerless to restrict religious activities unless, as they explained, those activities cause someone to, quote, work ill to his neighbor. That is, unless someone's religious expression actually directly harms someone else. Jefferson understood their concern, for he had already proven that it was his concern as well. He replied to the Danbury Baptists on January the 1st, 1802, thanking them for their kind prayers and assuring them that their free exercise of religion was indeed an inalienable right and therefore would not be meddled with by the government. Jefferson pointed out to them that there was, quote, a wall of separation between church and state, and that this wall of separation would prevent the government from interfering with or hindering religious activities. Jefferson, like the other founders, fully understood that the purpose of the First Amendment was to protect rather than prevent public religious expressions, and that this is what separation of church and state meant. In fact, for almost a century and a half after Jefferson's letter, there was no misunderstanding either about the purpose of the First Amendment or the meaning of Jefferson's phrase. Here's an example. In 1853, half a century after Jefferson had written that phrase, a group petitioned Congress urging them to separate Christian principles from government, with chaplains being turned out of Congress and the military, and Christian principles being removed from government in the official public square. They desired a so-called separation of church and state, but in the wrong direction. That is, instead of the government protecting religious expressions in the public arena because of separation, they wanted the government to remove religious expressions. Congress spent a year investigating that possibility and then emphatically rejected it, declaring,
had the people, the Founding Fathers, during the Revolution had a suspicion of any attempt to war against Christianity, that revolution would have been strangled in its cradle. At the time of the adoption of the Constitution and the amendments, the universal sentiment was that Christianity should be encouraged, but not any one denomination. In this age, there is no substitute for Christianity. That was the religion of the founders of the Republic, and they expected it to remain the religion of their descendants.
In short, there was no way Congress was going to use the First Amendment and consequently its so-called separation of church and state to secularize the public square. As they clearly affirmed, the intent of the framers had been just the opposite. In fact, 2 years later, Congress reiterated,
the great vital and conservative element in our system, that is, the thing that holds our system together, is the belief of our people in the pure doctrines and divine truths of the gospel of Jesus Christ.
That was Congress. Congress clearly refused to separate Christian principles from the public arena. However, it was not just Congress that refused to do so. The Supreme Court refused to do so as well. In an 1878 case, more than 3/4 of a century after Jefferson had penned a separation letter, the plaintiffs in that case invoked his separation of church and state phrase, hoping to use it to their advantage. However, that Supreme Court was not content to let them get by with just using the 8-word separation phrase out of context from Jefferson's letter, which, by the way, is what courts today do. No, rather than just cite the single phrase, the Supreme Court reprinted a lengthy segment from Jefferson's letter to prove the separation of church and state was intended to protect rather than remove Christian values and practices from public policy. The courts maintained that position for the next 7 decades. Then, in 1947, a radical change occurred. In the case Everson versus Board of Education, the court cited only Jefferson's separation metaphor, ignoring the rest of his letter and its clear context. It therefore boldly announced a new policy.
The First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach.
This was a brand new philosophy for the court. No longer would Jefferson's separation phrase protect public religious expressions, as it had for the previous century and a half. It would now become a mandate to exclude religious expressions and to secularize the public square. Significantly, as courts and secularists began to remove public religious expressions, they simultaneously clamored separation of church and state, claiming this is what the founders wanted. This was their great intent. So often have they repeated the separation phrase when talking about the First Amendment that many citizens today now believe that the phrase is actually part of the First Amendment, thus demonstrating the truth of a statement attributed to Dr. William James, the father of modern psychology.
There is nothing so absurd, but if you repeat it often enough, people will believe it.
Today's courts, in dealing with First Amendment issues, now repeat the separation phrase more often than they do the First Amendment itself. In fact, since 1947, the separation phrase has been cited in over 4,000 court cases, but the First Amendment's been cited in less than 3,000. In short, the courts have now elevated a single phrase from a private letter, a phrase completely reversed from its original meaning, above the actual language of the First Amendment itself. The Supreme Court, having announced its new approach in 1947, first nationally implemented the policy of public secularism in 1962 when, for the first time in American history, it ordered the separation of religious principles from education, ruling that it was unconstitutional for a student to pray voluntarily, to say a voluntary prayer at school. So revolutionary was this decision that the following year, even the court itself acknowledged that this decision had been without precedent. However, the court's hostility toward voluntary prayer did not stop with that first decision. No, the courts continued to push the prohibition wider and wider and wider until, by 1985, the Supreme Court had even declared that it was unconstitutional for a student to pray a silent voluntary prayer at school. Now, frankly, I don't know how they know if someone is praying silently. I mean, after all, many silent prayers occur with heads lifted and eyes open. So how does the court know when to enforce the ban on silent prayer? Nevertheless, the hostility was such that the U.S. Supreme Court even declared that permitting silent voluntary student prayer was unconstitutional. In the landmark 1962 case, the court achieved its reversal of the Constitution's protection for religious expressions first by using the phrase separation of church and state without regard to its historical meaning, and then by redefining the meaning of a single word within the separation phrase, the word church. For nearly 2 centuries prior to that case, the word church in the phrase separation of church and state was defined to mean a federally established national denomination, such as was represented by the Baptists or Catholics or Anglicans or Presbyterians or whatever. However, in 1962, the court decided that the word church would no longer mean a religious institution, it would now mean a religious activity. So instead of the First Amendment being used to prevent the federal government from setting up a national denomination, which voluntary prayer certainly did not do, it now meant that the federal government must not allow a public religious activity, which voluntary prayer certainly was. This was the turning point in the modern interpretation of the First Amendment. And since that time, notice how that virtually every possible genre of traditional religious expression has been forbidden in recent years under this new doctrine. Imagine, for just short of 2 centuries, the First Amendment had prohibited the federal government from halting public religious exercises. But now, somehow, the First Amendment means just the opposite, all because the court took an 8-word phrase from a private letter and twisted and completely reversed its meaning, and then made that phrase a replacement for the clear wording of the Constitution. That 1962 case redefined the First Amendment, and it's notable for other reasons as well, particularly for its use, or lack thereof, of precedents. Recall that when the 1892 Supreme Court unanimously ruled that Christian principles must remain the basis of American laws and institutions, it had offered nearly 80 precedents as a basis for that decision. The 1962 case was just the opposite, providing virtually no precedents to support its removal of voluntary school prayer. The justices on the court were simply ready to move America in a new direction. So in essence, they simply announced, we'll not have voluntary prayer in schools anymore. We now think that that violates the Constitution. Within 12 months of that original decision, in 2 additional cases, the court reaffirmed its removal of voluntary prayer and then broadened its prohibition to include Bible reading at school. This was an even more radical reversal than the removal of voluntary prayer. Recall from the brief historical survey already presented that the founders relied on the Bible in education. Early textbooks quoted the Bible and used it to help students memorize the alphabet. Congress printed the first English language Bible for the use of our schools, and previous Supreme Courts ruled that government-run schools would teach the Bible. So, when the court banned Bible reading from schools in 1963, on what possible grounds did it justify its decision? If you want to see why the court did what it did, simply read the case for yourself. You can find it online, or you can go to a local law library and read it. And if you do, you'll see that in reaching its decision, the lower court had relied on the testimony of a psychologist who explained the danger of reading the Bible in schools. The Supreme Court then repeated that finding, reporting,
If portions of the New Testament were read without explanation, they could be and had been psychologically harmful to the child.
That's quite a statement. The court was no longer concerned merely about law and the Constitution, its constitutionally assigned role, but it had now appointed itself as the national child psychologist. In fact, in recent years, justices on the court have described the court's role not only as being amateur psychologists on a, quote, psycho journey, but also as being, quote, a national theology board, and, quote, a super board of education for every school district in the nation. That decision to remove the Bible from schools, just like the decision to ban voluntary prayer, was a reversal of all previous practice and rulings by the court on that issue. The court was simply announcing yet another new policy. In essence, it was just saying, the majority of the 9 of us on the court don't want the Bible in schools anymore. Following those 2 landmark rulings, courts continued to expand the new secular mandates outward. For example, in 1967, a federal court declared a 4-line nursery rhyme used by a K-5 kindergarten class to be unconstitutional. The court acknowledged that the word God did not appear anywhere in the nursery rhyme, yet the rhyme was still unconstitutional. Apparently, if someone were to hear the rhyme, he might think that it was talking about God, and that would be unconstitutional. This trend of hostility toward religious expressions continued in case after case, year after year. In fact, by 1980, the Supreme Court even addressed whether students could continue voluntarily to see the 10 Commandments while at school. The court acknowledged that the 10 Commandments in question were passive displays, just one of many pictures at school. That is, a student might see hanging on the wall a picture of George Washington, or a field of flowers, or a lighthouse on a seashore, or student artwork, or the 10 Commandments, or whatever. In fact, here is an original copy of the 10 Commandments that led to the Supreme Court case. They were not part of any curriculum. They passively hung on the wall, and like any other picture, a student could look at them if he wanted to, and if he didn't, he just walked on by. Nevertheless, the Supreme Court ruled that allowing students even voluntarily to see a copy of the 10 Commandments at school was unconstitutional. The 10 Commandments had to come down off the walls. Notice the court's explanation.
If the posted copies of the 10 Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. This is not a permissible state objective.
What a statement. We can't let students see the Ten Commandments. If they saw them, they might read them. And if they read them, they might respect them. They might even obey them. You know, things like don't steal and don't kill. That would be unconstitutional. Significantly, generations of American leaders and courts before that ruling had regularly affirmed that the Ten Commandments were the basis of civilized behavior in our society and the foundation for much of our legal code. In fact, speaking about the Ten Commandments, John Adams unequivocally declared,
"If thou shalt not covet and thou shalt not steal were not commandments of heaven, they must be made inviolable precepts in every society before it can be civilized or made free."
This was the clear declaration of John Adams. And by the way, I think he'd qualify as an expert on the First Amendment. After all, he personally oversaw its framing in the U.S. Senate, and his signature is one of only two that appears at the bottom of the Bill of Rights and the First Amendment. And he forcefully asserts that the Ten Commandments must be fundamental precepts of our civil society. Founding Father James Wilson also affirmed the importance of divine law, such as the Ten Commandments. James Wilson was the distinguished founding father who served many years in Independence Hall, signing both the Declaration of Independence and the Constitution, one of only 6 founders to sign both documents. He was then appointed by President George Washington as an original justice on the U.S. Supreme Court, where he served in the court for its first 9 years, including when it met here in this room next door to Independence Hall. Significantly, James Wilson was the founder of the first organized legal training in America. In fact, these law books contain the lectures he delivered to law students here in Philadelphia while simultaneously serving here as a justice on the U.S. Supreme Court. These are really the first American law school textbooks. James Wilson, having helped write the Constitution and then taught students about it, would certainly know what is and is not constitutional. So did he think that divine laws such as the Ten Commandments, must be kept out of public view? Here's what he clearly explained to students.
Human law must rest its authority ultimately upon the authority of that law which is divine. Far from being rivals or enemies, religion and law are twin sisters, friends, and mutual assistants. Indeed, these two sciences run into each other.
James Wilson certainly did not believe that the Ten Commandments or divine law should be kept from public view, and many other founders made similarly explicit statements. Furthermore, early courts issued literally dozens of rulings citing from the Ten Commandments as a legal authority on numbers of diverse issues. In fact, so clear was the civil recognition of America's reliance on the Ten Commandments that for decades, one was more likely to find a copy of the Ten Commandments hanging in a government building than in a religious one. Yet despite this lengthy history of reliance on the Ten Commandments, the court suddenly held that students could no longer see the teachings that are the basis of our laws. Returning to the 1962 decision that initiated the official hostility toward public religious expressions, the entire controversy had begun over a 22-word voluntary prayer that the court struck down in the Engel Vital case. That little prayer, which led to the end of all school prayer and so many other public religious expressions, had simply stated,
Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country.
That little voluntary prayer, which only acknowledged God and didn't even mention the word Jesus, was so bland that 8 years later it was ascribed by a court as a, quote, to whom it may concern prayer. Now that's bland. That prayer acknowledged God only once, the same number of times that God is acknowledged in the Pledge of Allegiance, and only 1/4 the number of times He's acknowledged in the Declaration of Independence. Yet somehow, that single voluntary acknowledgement was unconstitutional. Since this prayer had merely acknowledged God, the court even went so far as to investigate what percentage of the nation at that time did believe in God. The court reported that only 3% professed no belief in religion, no belief in God. Significantly, 97% of the nation did believe. That 22-word prayer was consistent with the beliefs of nearly all the nation. Yet the court said that it was unconstitutional for students even voluntarily to say what almost the entire nation believed. This was another first by the court, in addition to 1, having ignored the actual wording of the Constitution, 2, having set aside precedent, and 3, then having elevated an 8-word phrase from a private letter above the Constitution itself. The court, having no constitutional basis and nothing more than its own preference, now 4, sided with the 3% against the 97%. This was the first time in America's history that 3% had become the majority. This decision initiated the current policy whereby the philosophy of the small dissident group, that is the 3%, becomes the standard by which the rest of the nation, that is the 97%, must conduct its public affairs. In the unconstitutional 22-word prayer, there had been 4 categories over which God's blessings had been petitioned. 1, us, that is students. 2, parents, that is families. 3, teachers or schools. And 4, the country or the nation. Significantly, for almost 2 centuries, the courts had used biblical principles in addressing policy issues in all 4 of those areas. For example, in the area of families, courts noted that civil laws made divorce difficult to obtain because the Bible made divorce difficult to obtain. And even 20th century courts pointed out that God, not government, had made marriage and the family. Therefore, government did not have a right to regulate something it hadn't made. Courts even set forth biblical lessons citing Adam and Eve and covering a history of God's dealings with marriage and the family, concluding that since it was God who had created marriage and the family, the court would use His standards in dealing with those areas. The courts similarly applied biblical principles to the other 3 categories as well. But in 1962-63, the Supreme Court reversed that practice. So, did the court's decision to change national policy and expunge God's principles from public affairs have any measurable effect? Statistics seem to indicate that it did, and in ways that the founders themselves had predicted. For example, consider the changes that occurred in the first category, us, that is, students. George Washington, in his farewell address, accurately predicted what would occur if religious principles were separated from students. He specifically warned,
"Let us with caution indulge the supposition that morality can be maintained without religion. Whatever may be conceded to the influence of refined education on minds of impressionable structure, that is, on the minds of students, reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle."
Washington warned that excluding religious principles from education and students would result in a loss of morality. Statistics now confirm the accuracy of his warning. Consider the category of pregnancies for unwed teenage girls. For decades prior to 1962-63, birth rates for unwed teen girls had remained relatively stable. But with the court's exclusion of religious principles from students, birth rates for unwed teenage girls immediately skyrocketed by 400%. Similarly, birth rates for junior high girls had also been low.